Hello, everyone. Today I want to talk for a few minutes about the CDC moratorium and what's happening there and what's really happening in the courtrooms. There's maybe been quite a bit on social media and different videos about it. So back in September 4th, I think is when it became effective, the CDC issued its moratorium nationwide on evictions. And they wanted to make it so that no evictions can take place until the end of the year based on non-payment of rent. You could still evict on other reasons. And what has been happening over the past month or two is sort of all over the board. And if a tenant signs one of these affidavits, right, then it's called a declaration. They can give it to their landlord. Then the landlord cannot evict them for non-payment of rent. And the tenant has to opine on 6 or 7 different things as being truthful. There was a lot of uproar in the legal community over what the declaration meant and what the CDC was going to do to interpret it. And the only guidance they came out with that really addressed the declaration itself was to say the parties can always kind of cross-examine on the issue of truthfulness and whether or not the statements in the declaration are true because they are pre-printed by the CDC. The tenant doesn't write anything of their own. They just simply sign it. And some of the courts are actually handing this out in court. Some of them are not handing it out. Some are requiring it to be filed with the court. Some are requiring landlords to attest that they did receive it or did not receive it. So I think this is in general, a terribly written document, and it's creating a lot of confusion. And we actually had a hearing on this last week. We don't have a ruling yet. It was in Warren Township Small Claims Court, and we contested on behalf of the landlord and provided documents that the tenant's declarations were false. And we attacked 3 of the declarations as being false. The tenant did not show up to the hearing. The court still let us or made us go through that and took testimony from our client, and we also submitted evidence. And it was very plain during the hearing that the court was uncomfortable being having a challenge on this issue. And he actually said that at the end of the hearing that over the past 6 weeks, out of hundreds of cases that have been called in his courtroom, this is actually the first time that anybody actually litigated and opposed the declaration as being untruthful. And he just wasn't, he's like, what do I do with this? I believe everybody. Those were his words. I believe everybody. So what do I do? Maybe your remedy as a landlord is to go and try to sue him for perjury or something else. And I said, no, Your Honor. The CDC issued guidance even this week saying that we have a right to challenge the truthfulness, the veracity of what's in this declaration. And if it's not true, then the tenant is not protected by this CDC moratorium. The court's in a very difficult position because the language of the declaration is very, it's not well written. So I'll give you a couple examples. The first declaration is that the tenant has used best efforts to obtain all available government assistance for rent or housing. Well, best efforts is impossible to determine. What qualifies as best efforts is unknown. Also, what is all available government assistance? So there's lots of government assistance programs available for different things. There's even utility help from different organizations. There is the trustee's office in the county level has rent assistance. Then there are specific rental assistance programs during COVID that are also provided. And in our particular case, it seems like the person that applied for rental assistance, the only one that did, was the wife of the tenant. The wife was not on the lease. The wife did not qualify. The household income actually increased rather than decreased during COVID. So the rental assistance was denied. And the legal question becomes, well, did the tenant who's on the lease, the defendant, even apply? And our position was, no, the tenant didn't even apply. Somebody else did. They weren't qualified with him. And so he either doesn't qualify or he didn't even apply. and there was no evidence submitted by the defendant tenant that he had applied for any other kind of rental assistance. And so it kind of goes on, from there. So we had an interesting hearing. We don't have a ruling yet. It'll be coming out here soon. When it does, I'll let you know how that went down. But we also asked the court to take issue with the statement that the tenant is, quote, unable to make full rent or make a full housing payment, right, because of loss of income. And again, that went back to the fact that the rental assistance program said, no, your income went up rather than down. You didn't have a loss of income. And then the fourth one that we challenged was, it says, I'm using best efforts to make timely partial payments that are as close to the full payment as possible. And again, this is terrible language to try to deal with, because best efforts, nobody knows what that means. Timely partial payments is also difficult to ascertain from a legal standpoint. The record is that here it is October, middle of October, and the last rental payment was made in May. So there were 0 payments from May through middle of October. So we would contend on behalf of the landlord that there was not a best effort to make payments, and no evidence showing that perhaps there was 0 income during that time. That doesn't seem to be what was actually happening. So we were addressing the truthfulness of all this. There were other people on the Zoom call. I got a call right afterwards from another lawyer that does 300 to 600 evictions a month pre-COVID. And he said this was really the first time that he'd heard anyone address it. None of his clients had done it. So I want to come down to the bottom line of some of this, is that as a litigant, no matter what side you're on, you have to litigate these issues. If you don't, you're going to lose on them. So up to the time that we've at least made an argument and made a record, there's been no landlord who has even tried to challenge the truthfulness or the veracity of these moratorium declarations. So you have to fight on it and see where it goes from there, take the next step. I don't know what that's going to be. We need to see what the ruling is. So number one, try to challenge them. Number two, if you can, I mean, if the tenant qualifies, then of course don't challenge it, maybe, unless you want to just do it on constitutional grounds. But in this case, we don't think the tenant qualified on at least 3 out of the 7 criteria, so we were challenging that. Love to hear from you. I hope that helps you, and to know that it's being handled differently in every single court in the state of Indiana, at least. All right, have a great day.